for lack of a better word.
I'm still trying to figure out what this expert going to testify to.
The expert can analyze the training logs, the methods employed by the handler, as well as the techniques utilized, can basically do an analysis of the dog by way of its training, the type of training it's received, type of the training the handler has received, and also the procedures that were employed by the handler, and basically also assist the court in giving a background on how these dogs are trained. What are their customary? What is customary as far as these canine animals are concerned, as to their behavior, and the error rates, which will play a huge role in the court determining if this type of evidence is going to be admitted. Quite frankly, I believe this would be more of an issue that's going to be laid out and hashed out in a pretrial hearing. However, we need to be able to retain this expert to be able to testify before the court and to assist the court in making determinations whether this type of evidence is going to be admitted at all.
And where is this expert from?
I know the university. I believe it's Georgia. Oh, excuse me, Alabama. It's Alabama.
And has this expert testified before?
Yes. Not in this case.
Now, I know not in this case, but I'm talking about, has he testified in other cases?
Yes, he has. And I can take it a step further in assisting the court. The dog handler testified in the bond hearing in this case. And not only have I consulted with this expert as to the training logs, we've done a substantial amount of investigation into the background of these canines. This expert has also reviewed the testimony of the dog handlers and has looked at some of the discovery in relation to the actual work that was done in this case.
State, any comments? Ms. Drain?
The only thing that strikes me from his commentary is that this person's work should already be done, since the bond hearing took place almost 2 years ago and all of this discovery has been out there. So I would imagine the only thing they're asking for is a certain number of hours and travel expenses. But
that is all I'm asking for. I'm pretty confident in our position, though you never can be too confident, and saying that this will result in a pretrial hearing where Your Honor is going to have to weigh some significant issues as to how far the state can actually go with this type of evidence. And Ms. Drain-Burdick is correct. It would be a limited amount of hours to just prepare and testify at the pretrial hearing, and if it turns out that he is needed for trial, again, we could always ask for more hours at that time.
JAC?
I'll defer to the court's expertise in this matter. I would ask the court to severely limit, if the court is inclined to grant this expert, to severely limit any travel and rates and time spent in this matter, in light of the fact that the bulk of the expert's work has been done already.
Thank you. How many hours are you looking at, Mr. Baez?
I would be proposing 20 hours.
It will be granted up to 20 hours, and then we'll go from there. Next.
The next issue, Judge, would have to deal with, and I'm not certain this is the first time I've had to deal with this, public records requests. we would get charged for public records requests should we seek from an outside agency or from a governmental agency certain documents for our investigation. I do not know how the court would prefer to deal with that, but I included it in my budget request. I can give you, Your Honor, a perfect example. We had requested some time ago the tips that were given to law enforcement when they had the crime line set up for Kaylee Marie Anthony. We were told that that was not part of discovery. In fact, the court ordered that it was not part of discovery, and that if we wanted this information, we would have to get public records. We would have to submit a public records request to the Sheriff's Department. As much as we disagreed with that position, we started to attempt to make these public records requests. The first set of discs cost approximately $1,000, and I guess someone found it very funny over there to give us the psychic tips first. And so we ended up paying approximately $1,000 for psychic tips. And at that point, we realized that we would revisit this issue at a later time. But certainly that is one of the motions that we plan on possibly revisiting with the court. If not, it's going to have to be done by way of public records requests, and just not sure how the court would like to handle that. I set aside an estimate of $5,000, and I don't know if that's high or low, but based on my previous experience with public records requests in this case, I thought it was a reasonable amount just based on my prior experience.
Just a second, let me check something. JAC wants to be heard on this issue of public records request.
Yes, Your Honor, to the extent that there are any specific public records that counsel is requesting other than the tips he has outlined, I would request that the court require that those records be identified with specificity by motion, and the court thereupon rule on whether they're reasonable and necessary to have the taxpayers pay for them. If I may, I'd like to address other miscellaneous costs. While I'm here, I would like to point out that any copies of any court pleadings, filing fees are waived, certified copies of any orders or final judgments, service of subpoenas, subpoena fees, service charges for collecting and dispersing funds, or any other cost or service arising out of this matter under 57.081 Florida statutes is provided without prepayment to indigent defendants. And I would also point out that service of process is provided by the Orange County Sheriff's Office without prepayment for indigent defendants, and that there should be no request for those sort of costs. Again, regarding the public records, reasonable and necessary is the standard, Your Honor, and I will defer to the court's judgment in that regard. Thank you.
I would just add a brief, unless Your Honor is ready to rule out.
Speak up just a little bit, Mr. Baez.
Yes, I would just add a brief rebuttal to that, and that is that it would be impossible to do pre-requests for this type of information just to do the sheer volume, and in addition to the fact that a lot of this would fall under investigative confidential investigations. If we're investigating a specific witness and this person's been arrested for something else, or we'd like to look into that prior case or something like that, we'd have to go and get the public record, the court dockets or the court documents, including arrest reports and other possible discovery. So it'd be kind of difficult to come before the court every time we wanted to do that.
I will grant your request and set a cap in the amount of $3,500 at this time, and then if you exceed that, then you can come back and justify more. But I'll give you $3,500. That should not impede your investigation. If you need more, you can come back. That'll solve that problem. Okay. Next request.
Yes, the only other request we would ask that be done in camera. We actually got through all of them with the exception of this one request.
Okay. Before we get to that, I'm going to need a hint, but let's jump to your last thing that was scheduled. Your request that the state of Florida respond in writing to your motions. Yes, you're going to handle that, Mr. Mason?
Wait for you. Your Honor, there are numerous motions pending that bear on how the trial will be conducted and or pretrial motions. Additionally, you have up there, you get out before I can give it to you, a judge's copy of a motion I have filed today with respect to reconsideration of prior rulings pursuant to the rules of judicial administration. It would be so much easier for this case to be prosecuted and defended and move through the system if the state would be required to respond to the motions that have been filed. I know where we are, across the street in federal court. It's required in every motion. If they did that and we knew what positions they were taking, there would be a lot of things that could be resolved even perhaps between counsel or by the court without having to have hearings. But since the state has chosen not to file any responses to the motions, we don't know what position they take, and so it takes a lot more time to have to deal with it. And so we're just asking, okay, look, either let the state say we have no objection to the motion, or cite the reasons therefore. It's my understanding historically in this case, before I was in it, that the prior judge requested and required only that if there was going to be a hearing and either side had some case law they wanted to use in the hearing, that they had provided to the other side 2 weeks in advance. That's all that's been done. So we're just simply asking that, look, death is a different case. This is an important deal. We know the rules regarding it. It's a heightened obligation on both sides. We file motions with memorandums. We would like the state to have to file a memorandum stating their point and their basis of their point so we can go further with it.
Mr. Mason, one question. By doing this, would that alleviate the necessity of hearings on these motions?
It very well could, without knowing the responses. I don't know. I know that there are many motions in these types of cases that, frankly, are done for protecting records in future and long-term possibilities that have been ruled on and can be ruled on by the court. But without positions taken by the state, we don't know. I suggest to you that there are likely to be many motions that if a response and memorandum was filed, you would have it. If they don't require evidence, we don't need to come in and reiterate to you, or we used to say, blow smoke over the papers. If we have the memorandum of the case is there, why, you're fully capable of reading them and understanding. You've got Judge Eaton's book, and you've got the rest of the things there to deal with. Why, we would like them to file responses and see if we need to have a hearing. You could decide on many of them whether a hearing would be necessary or not. You may decide, I don't need to have a hearing on this. I've heard it all before. Here it is, and I've considered both sides. Or we may want to have a hearing. We may specifically have to have a hearing for some matters that require argument outside the papers. Again, analogizing to the federal court proceedings, it's very common we file a motion, the other side has to do it, and there's a request for an oral argument, a request for presentation or not. So I like to see it done on a little higher plane.
I think that's a great idea.
Response from the state of Florida.
Go ahead on yours. I'll go.
Your Honor, there's two different tracks that we're following here. Obviously, there's the death penalty motions and then motions directed towards the evidence in the case. It's been our experience so far in that those motions that we actually respond to in writing, we end up having a hearing anyway, and then both sides essentially get up and reiterate ad nauseum, perhaps, that which they've already written. So it is our position, were that to occur in this case, that requiring us to respond in writing is a colossal waste of time. The other issue to date has been that the legal arguments presented in the non-death penalty motions have not been that complex. We also assume that when the defense prepares their motion and their memorandum, if they so choose, that they have thoroughly researched that matter and are anticipating what our response may be at hearing. Now, of course, if the court, in reviewing the filed motions ahead of an actual scheduled hearing date, would like us to brief a particular legal issue, we are more than willing to do that. Mr. Ashton will speak as it relates to the death penalty cases, death penalty motions, because when we have strictly legal issues, and I'll give you an example, we had the C4 motion to dismiss earlier in the case. I filed a response to that. They filed a response to my response. We had a hearing where we talked about the whole thing all over again for probably 2 hours. The other issue is that if it is a motion, such as a motion to suppress, which we have not had yet, they don't lend themselves to pre-hearing responses because the evidence in that situation has not come out yet. If the court would require or request a post-hearing briefing on some of the issues that come out in an evidentiary motion, we're willing to do that as well.
Mr. Mason?
It comes to mind.
Would you like to hear?
I'm sorry.
The death penalty issues are separate.
Okay, let him speak to the death penalty issue, and then you can respond, Mr. Mason.
We, as to the death penalty motions, I made exactly the offer that Mr. Cheney is suggesting to Ms. Lyons early in the case, and it was declined. I agree that the bulk of the death penalty motions should be handled by pleadings without hearings. Ms. Lyons was not willing to agree to that procedure. If that has now changed, then I certainly would be interested in doing that. To echo what co-counsel said, it doesn't make any sense for me to spend the time to write out my argument and to come into court and give it. Some of the motions that have been filed have referenced facts from either media accounts or other things, in-camera hearings. So it's impossible for me to know whether the defense actually intends to offer any evidence or not. So I think if we set up a system where the defense files a motion and in that motion specifically says, I want an evidentiary hearing or I merely want an oral argument, then I'm in a position to respond and perhaps the court to rule without a hearing. So I think the procedure needs to be set however the court likes. But at this point, we just don't want to do both.
Mr. Mason?
Sounds like we may be getting close to some way to resolve this. I do want to respond to a couple of things. There are some death penalty motions that do not require repeated argument, as Mr. Ashton says. That is correct. But there are others that do. And in fact, on Tuesday of next week, we're scheduled to argue before you, Ms. Lyons will, I think 4 such motions. There are others. Another example of why we would like a response, Mr. Baez reminded me there's an issue about the use of some photographs, alleged photographs of the conduct of Casey Anthony. Well, a whole overwhelming majority of those photographs, or a significant amount of those photographs, are photographs taken before any relevant issue in this case came to light, and before any missing child.
With the court reporter, Mr. Technician, kill the microphones. Sound back on? Anything else, Mr. Baez and Mr. Mason?
None, Your Honor.
No, sir, thank you.
Actually, I'm sorry.
Well, Your Honor, if we have just a moment or two, there is one other thing I'll bring up, an oral tennis request.
I generally don't like to deal with oral tennis requests, but go ahead and make it, and then we'll see.
Ms. Anthony has requested to waive her appearance in these types of proceedings, and we are requesting that she be allowed to waive that. You're certainly entitled to, I'll tell you, have a colloquy with her about her knowing and intelligent waiver of her appearance and presence in these proceedings. Only thing that is served by bringing her here, like for today, is to put her in a fishbowl. That adds nothing. She doesn't want to be involved with it. She'd rather stay where she is. And this case is, once again, death is different. The death case involves her. And every time that she is subjected to the hordes of the media talking about what she wore, what her hairstyle was, what expression she had on her face when talking to counsel or anything else, just adds more fuel to the fire. She doesn't want to come, and we'd like to waive her appearance in all regards unless we request it or there's an evidentiary hearing that would require her to be here.
State want to be heard?
Yes, Your Honor. We argued this motion more than a year ago. The state had asked that Ms. Anthony be brought to court for all substantive hearings. I think this would certainly qualify as a substantive hearing. We do it, or we did request it back then, and we request it now, mostly for appellate reasons, as well as Ms. Anthony should be here for all future hearings until the course of the trial. Which makes good sense.
Thank you, Mr. George. Mr. Mason, anything else?
Prior ruling notwithstanding, the Judicial Rules Administration 2.330, subparagraph of the Lays provides for reconsideration. I have provided some others to you that we'll deal with. It's her rights, and there's nothing to be gained except, as I said, to try to exploit the situation. She doesn't want to be here. She has a right to waive that. She has a right to waive a jury trial. She has a lot of rights that she can waive with your understanding that they're freely, voluntarily, intelligently being made. We request that.
The problem, Mr. Mason, is in death penalty litigation, there are numerous substantive motions that will come up that may or may not require her presence and her assent to what may be going on. There are opportunities for stipulations of things where I would need to inquire whether or not she concurs with the stipulation. It has been my experience that in capital cases that defendants need to be present during those proceedings because what invariably happens, as you are well aware, if Ms. Anthony is found guilty of anything, it will lead to a post-conviction relief proceeding, 3850s or 3851s, depending on what the outcome of this case may be. And it always gets back to my lawyer didn't tell me this, I didn't know about this, and if I would have been there, I would have did A, B, C, and D. So the request will be denied. The one thing that I would not require her to attend is sometime next week I will be sending out the amended trial order, setting status hearings, checking on the progress of the case. We won't be arguing motions, but I will be checking to see if you're complying with the discovery deadlines, if you're having any problems, and making sure that if there are motions filed, are you going to set them for hearing, things of that nature, nothing substantive. So she will not be required to attend those status hearings unless she wants to come. So the request will be denied, but on a case-by-case basis, On some motions, you can raise it again. You're not barred forever in bringing it up again.
Your Honor,
Ms. Drain?
who would have responsibility then for notifying court security as to which motions she wants to attend and which she wants?
My JA always communicates with court security as to, they always check with her and she checks with me every time to see if she needs to be transported.
The only other issue, if the court has another second,
Yes, ma'am.
you've issued an order requiring that we come up with a discovery schedule within the next 2 weeks.
Yes. Deposition schedule.
Yes. Obviously, they have a lot of depositions that they want to schedule, but we're sort of in a quandary here where they haven't even listed these experts. It appears from today's proceedings that they are ready, perhaps, to list some of these. We would ask that the court order that they do that immediately for those that they know they're going to list so that we can begin the process of scheduling these depositions, because we have nothing to present to the court until they list witnesses who are ready to be deposed. And
Mr. Baez?
They haven't concluded their work yet. We haven't even seen we haven't had the opportunity to go to the Orange County Sheriff's Office and have the actual viewing of a majority of the evidence. Granted, they've been consulted with, but there's certain things that we simply just do not have yet.
Okay, this is what I want you to do. Do the ones that you know, but when this order comes out, there are going to be discovery cutoffs where all the examinations and all of that must be done. And if you don't get them done, you're going to have to give me a pretty good reason why they were not done. So do the ones that you have, that you know about, and then we will deal with the rest later on. But I want to know the ones that you currently have, and you end up having to supplement that as soon as you add it to the witness list, and I will deal with that in the discovery order.
Yes, sir.
And I mean pre-trial order, rather. Anything else, folks?
Yes, Mr. Mason had pointed out to me that under jury selection I had the consultant, but there was also the aspect of travel for the attorneys. Wherever we go to select the jury, I did not include that in the budget, and I don't know if Your Honor wants to just set aside a certain amount or cap, or how the court would prefer to handle it.
I kind of think that according to the JAC, Mr. Mason is pro bono, right?
Yes, he is.
And
Mr. Mason's travel would be covered, I think, according to JAC, because it's pro bono. I'm reading your manual. But privately retained is not covered. Am I correct, Mr. JAC attorney?
Your Honor, we do pay for travel for pro bono attorneys when there is only one attorney on the case.
Well, Mr. Mason is pro bono.
I understand that Ms. Anthony has paid counsel, and we do not pay for travel for retained counsel. And pursuant to our policies and procedures, travel for pro bono attorneys is only made when the pro bono attorney is the sole attorney on the case. So we will object to that.
Unfortunately, Mr. Baez, let me consider that, but I'm looking at their manual, and it says if you're privately retained and you're a lead counsel, you were privately retained, those expenses are considered overhead. So I would not be asking the taxpayers to pick up that cost.
That's understandable, Judge. In the event that the jury selection, either location or the time involved, ends up being a little more extended than we thought it would, even at my $5 an hour, I was wondering if perhaps if the court, under its discretion, realizes that it's was a little more than anticipated or could be anticipated, that I would be free to move for this at a later time.
You're always free to move. Whether or not you get it is a different question, but I think the regulations, which I'm bound by, are quite clear. But jury selection shouldn't take any more than a week.
Did you say 1 week?
Yeah. How long does it take to get 12 plus 6 jurors, 18?
With the length of the trial and anticipated hardship and death penalty impact, the last one, the Serrano case, took 3 weeks to pick a jury, 645 individual, more than I mean, I don't know.
Well,
I think
you will be doing individual voir dire, but it's going to be a little different. We will bring...
Judge Roberts.
Huh?
That was Judge Susan Roberts on that case.
I know Judge Susan Roberts, but we will bring in a panel. We will randomly select, the clerk will randomly select them, and you will question them one at a time. And after you've asked them all the questions you want to ask them on hardship, pretrial publicity, death penalty, anything else, you will then be asked to exercise a peremptory or a challenge for cause. And we will do that until we have 12 plus 6. So in other words, we're not going to end up talking to 200 folks first and then willing it down. We're striking them as they come up.
Having done that procedure with Your Honor before, I think a week should be fine.
We'll see. We'll do our best.
Oh, I know, and what we will do is a somewhat detailed schedule. But we'll get to that as we progress, because in order to do it, we're going to need 2 courtrooms. 1 courtroom to hold them, and 1 courtroom to question them one-on-one. And I figure that it'll be an average of 15 minutes per juror, give or take a few, because you're going to have some folks that, with the magic question, that they've heard about this case and they can't set aside their opinion. And, you know, once they say that, there's no need to ask them any other questions.
We anticipate also a pretty comprehensive jury questionnaire that we would present well in advance, hopefully. That may help.
Yeah, that may help. I've never been a real fan of jury questionnaires because I always get the same questions asked again, so might as well do it one time. But we'll see. I haven't formulated any opinions on the jury questionnaire, but anything else, folks?
Nothing else. No, sir.
Okay, this court will be in recess. I need to see Anna for a second.